Good morning, good afternoon, and good evening. My name is Sinta Ramadhani, and I'm not alone. I'm with my friend, Nadira Farida. On this occasion, we will both discuss the employment agreement contract. We will explain all the contents of the contract. But before we get into the detail one by one, allow me to explain what an employment agreement is. An employment agreement, often known as an employment contract or job contract, is a legally binding document that establishes the term of the employment relationship between the employer and their employee. Employment agreement is crucial as it clearly defines the roles, responsibilities, salary, benefits, and conditions under which the employment relationship will operate. It's typically finalized and signed by both parties once the employee agrees to the job offer, ensuring mutual understanding and agreement. And now, let's take a look to the example of the employment contract. We have the Leviathan Mineral Group Incorporated Employment Agreement. This is the first part, or it can also be called the opening part or the introduction part of the employment contract. The opening part of the employment agreement must include the name of the employer and the employee to make clear who are the parties to the agreement. As you can see, the employer is Leviathan Minerals Group Incorporated and the employee is Samuel Kaikonzia. And then there are the effective dates of a contract is the date on which the parties intend for the term of the contract to take effect and become legally binding. It's important to know the effective date of a contract because it can impact the rights and obligations of the parties under the contract. After the introduction part, it's important to know the employment agreement's detailed essential aspects. Number one, the employment. These contain a description of the work to be performed to make clear what the employee is expected to do. Any good employment contract contains a message of information. And we are not just talking names and address here. Make it clear what the position is about. Consider including what sort of tasks are expected to be completed by the employee, who does the employee report to, who is their closest boss, are there extra responsibilities, and anything related to job description. Number two, the terms part contains the agreed hours or an indication of the hours that the employee will work. This includes agreement on any or all of the following: the number of an hour, the start and the finish time. Here it is mentioned that the initial term of this agreement shall commence on January 1st, 2011 until December 31, 2012. From the commencement date, a term also contains the day of the week the employee will work. Number three, a good employment agreement must contain compensation. Typically, compensation refers to monetary payment given to an individual in exchange for their service. In the contract, compensation is what is earned by employee. The wage rate or salary payable must be equal or greater than the relevant minimum wage and how it will be paid. Aside from salary, there are other benefits that will be received by the employees, including health insurance, paid vacation time, retirement plan, dental insurance, life insurance, or disability insurance. Number four, in a confidentiality or non-disclosure agreement, parties agree to keep private non-public information received during a business relationship, including in the early stage of exploring a potential business relationship. Reasons for confidentiality and non-disclosure agreements arise in a wide variety of contexts, including mergers and acquisitions, joint ventures, sales and service, employment, and intellectual property licensing. Employers ensure that employees understand the boundaries and the importance of keeping certain information secure. But aside from the things that I mentioned above, there are exceptions of the term confidential information, includes the information in 4.2.1 to the 4.2.4, including confidential information and non-disclosure clauses in employment agreements, also foster a culture of trust and responsibility. Employees are made aware of the value and sensitivity of the information they handle, which promotes a sense of duty and integrity. This understanding is essential for the seamless operation of the company, as it ensures that all personnel are aligned in protecting the organization's assets and reputation. Number five, termination. Contract termination refers to the formal process of legally ending a contractual agreement between parties. It can come to an end due to the end of the term, misconduct, immoral behavior, poor performance, or force majeure, death, and disability. An employee or employer can decide to end terminate an employment contract. This may be done by an employee resigning or an employer dismissing an employee. Termination for task issues when the employee's actions are against policy and may lead to serious repercussions for the company, clients, and other employees. Termination of employee service with cause may be necessitated by a violation of the company's code of conduct or continuous poor performance.
Hello, I'm Nadira Faniza, and I will continue my friend's explanation of this employment contract. 5.4 Termination without cause. During the term of this agreement, the company shall not dismiss the executive without valid reason. 5.5 Termination by the executive. The executive has the right to terminate this contract at any time during its validity without the need for a reason. However, if the executive chooses not to renew the contract and give notice to the company, this will be considered of a voluntary resignation and not termination with a good reason. The executive may only terminate the contract for good reason after following the good reason process. Good reason includes 1. Significant reduction in the executive responsibilities, authority, or duties. 2. A significant reduction in executive base salary unless it is part of an overall pay cut based on the company's financial performance, which also applies to all our most senior management employees. 3. Material breach of this agreement by the company. And then the good reasoning process consists of 5 steps. 1. The executive in good faith determines that one of the good reason condition is met. 2. The executive notifies the company in writing of the good reason condition within 90 days of the incident. 3. The executive cooperates in good faith with the company's effort for a minimum of 30 days after notifications to resolve the issue. 4. If after such effort the good reason condition still persists, the executive might terminate the employment relationship within 60 days after cure period. And 5. If the company successfully resolves the good reason conditions during the cure period, then the condition is deemed not to have occurred. And the next 5.6 Notice of terminations. And the termination of the executive employment by the company or the executive shall be delivered by way of written notice of termination to the other party to this agreement, except for termination of employment as specified in sections 5.1. For the purpose of this agreement, termination notice refers to a notice indicating the particular termination provisions relied upon in this agreement. And the next about death of terminations. Death of termination has different meanings depending on the reason for termination of the executive employment. For example, 1. Death. If the executive dies, the termination death shall be the death of his or her death. 2. Disability or company reason. If the executive employment is terminated due to disability, then the termination date is the date the notice of termination is given. And 3. Resignation without good reason. If the executive resigns without good reason, then the termination date will be 30 days after the date the notice of resignation is given. 4. Termination of employment by executive without good reason. If the company terminates the executive employment without good reason, the termination date shall be 30 days after the date the notice of termination is given. And the last 5. Termination of employment by the company. If the company terminates the executive employment with good reason, the termination date shall be the date the notice of termination is given after the cure period has ended. The company reserves the right to accelerate the termination date if the executive resigns, even if the executive has given a notice of resignations. This acceleration shall not be deemed to be a termination of employment by the company under this agreement. And next, we talk about compensations upon terminations. Termination generally. When the executive employment with the company terminates during the contract period, the company shall pay or provide to the executive or his or her legal representative the following unpaid items of salary-intensive compensations, ordinary reimbursement, accrued but unused leave, and other benefits accrued under the company employee benefits programs. Payments of all of these accrued benefits must be made by the company within 30 days after the date of termination of employment. And next, we talk about termination by the executive with good reason. If the executive terminates employment with good reason, the company will continue to pay accrued benefits to the executive until the termination date. However, if the executive signs a general releases of claims in a format and in a manner approved by the company within 30 days of receiving the release and does not revoke if during the 7 days revocation period. Part 1. If the executive is terminated, the company will provide severance by equal to 12 months salary and average bonus. Severance will be paid in 3 equal monthly installments starting from the first payroll date following the date of termination or after the 7 days revocation period for discharge, whichever is later, in accordance with sections 409A of the Internal Revenue Code of 1986. Each installment payment is considered a separate payment. Average incentive compensations is defined as the average annual bonus over the previous 3 fiscal years or shorter period of employment. Special bonuses such as sign-on bonuses and retention bonuses are not included in the severance calculation. If the executive breaches Article 4 of this agreement, severance payments shall cease. Part 2. On the date of termination of employment, all stock options and other share-based awards held by the executive shall vest and be exercisable or transferable. This entitlement applies even if the executive is not employed for 12 months after the date of termination of employment. Part 3. Terminated executive can remain in the company's group health, dental, and vision program for 24 months, provided they pay premiums at the same rate as active employees. It should be noted that 1. The continuation of these health benefits will affect the executive right under the Consolidated Omnibus Budget Reconciliation Act of 1998. 2. Executive must pay the premium themselves. 3. The participation period is limited to 24 months. And the last point, we talk about miscellaneous provisions. Point 1. Both parties to this agreement agree to sign all documents necessary to accomplish the purpose of this agreement. Point 2. This agreement is a complete and final agreement between the two parties related to all matters listed in it. This agreement replaces all provisions part. Agreement made by the parties, both oral and written. Point 3. Notwithstanding any part of this agreement which is held to be invalid or non-enforceable, the remaining parts of this agreement remain in force. This agreement shall be interpreted in light of commercially reasonable and true principles. Point 4. All changes or modifications to this agreement must be made in writing and signed by all parties involved. Point 5. This agreement is subject to the laws of the state of Delaware and shall be interpreted in accordance with such law. In the event of any dispute related to this agreement, whether by arbitration or other means, such dispute shall be resolved in Delaware. Both parties agree to submit to the jurisdiction of the state's court located in Delaware and the United States federal courts in the District of Delaware. Point 6. The party who wins a legal dispute is entitled to reasonable compensation for attorney fees. Point 7. The company shall withhold taxes and other deductions required by law from all payments made to the executive under this agreement. Point 8. All parties confirm that they have full authority and capacity to enter into this agreement and bind their counterparties. Point 9. All information, requests, demands, and other form of communication provided for in this agreement shall be in writing and delivered by any of the following means, either in person, by National Courier Service, registered letter or email with acknowledgement of receipt. All communications shall be addressed to the executive at the last addressing notified in writing to the company by the executive. Point 10. Any pronoun used in this agreement that refers to the masculine gender shall also include the feminine gender. This applies unless the context of the sentence clearly indicates that the pronoun refers only to the masculine gender. Point 11. In the event of any dispute relating to this agreement, including its breach, it shall be resolved by attribution by a mutually selected neutral attributor. The attribution proceedings shall be conducted under the auspices of the American Attribution Association. The cost of attribution shall be borne jointly by both parties in accordance with the provisions stipulated by the attributor. The decisions of the attributor shall be final and binding. A party decides to dispute with the attributor's decisions may appeal to a court having jurisdiction over the attributable award. Point 12. This agreement is non-transferable by the executive. The services agreed in this agreement are reserved for the executive only and cannot be delegated or transferred to any party other than the executive. The last point, this agreement may be executed in multiple copies. Each copy signed and delivered shall be deemed an original. However, all such copy shall constitute one and the same document and shall have the same legal force. The company is represented by Director of Leviathan Minerals Group Incorporated and the executive represented by Samuel Kaifongzia. Unfortunately, our explanation has ended here, and the shortcomings of our explanation we hope can be forgiven. Thank you so much, Miss, for your attention, and bye-bye.